Good evening, everyone. It gives me great pleasure to welcome you all for the today's continuing mediation program. I warmly welcome our director. Right now is not here, Santosh Gajan Bhatt, and Deputy Director Sri S.S. Bharat for the program. I welcome our today's resource person Srimati Geeta Menon, mediator, Karnataka Mediation Centre, who is enlightening us on the topic of family laws in relation to drafting mediation agreements. I also extend my warm welcome to the Additional Registrar General Kalburgi branch and Dharwad bench and all the mediators of Karnataka Mediation Centre, Bangalore, and the mediators of Dharwad and Kalburgi benches who have joined us today. I may now request our resource person, please come and ask. And I request Rukmini Menon to hand over the bouquet. Yeah, please come. No, no, don't. Yeah. Our resource person Geeta Menon, who is practicing advocate from past 35 years and as a mediator from 17 years, 19 years, 19 years. Now, I request our resource person to take over and commence this program, this session. Okay, please, madam.
Thank you, Vijayama. Good evening to all of you all. Today, my topic, which was not my initial selection, but I was told that some of the topics which I wanted to cover were already covered. But anyway, I'm going to deal with how a mediation agreement will be drafted vis-a-vis the family laws. Now, I'll start with Mohammedan law because most people find it a little difficult area to understand. Now, before I start on that, I need to understand if a Muslim couple comes for mediation, a case is referred, say it's the wife's petition for divorce or restitution, what would be the first point that a mediator has to bear in mind? What, according to you, is the first query that you will be putting to the parties? Can anyone tell me? No. as soon as you s- af- as soon as you start a mediation after your opening statement, when you know a wife's petition, I'm again clarifying, a wife's petition has come for mediation, what would be the first query to the parties? Not origin, but she is right, whether they are Sunnis or Shias, because the law governing Sunnis and the Shias are different. Now, if suppose in the wife's petition, suppose a husband comes with a petition or a suit or any case, I will use a word case. How are you going to, apart from asking whether they are Sunnis and Shias, how do you think you can mediate that case? Why? I think yes, because under the Mohammedan law, the husband does not have a provision to file a case for dissolution of marriage because already under the Mohammedan law, there are various methods of divorce which is available for the husband. Now, after you sort out whether they are Sunnis and Shias, you should understand what are the different forms of dissolution of marriage amongst the Sunnis and the Shias. Can anyone tell me what are the different forms? Okay, I'll make it easier. Talaq al Ihsan is the first most approved form as per the Quran. In that form, the husband has to pronounce talaq. wait for the iddat period, which is 3 months, and the talaq has to be pronounced when the wife is not menstruating. So if it is pronounced during the time of her menstruation, that talaq can be called as illegal or irregular. In that 3 months iddat period, you can reconcile. If there is no reconciliation happening in that iddat period, then that becomes a irrevocable divorce. The other form is talaq al ehsan, sorry, hasan. In that, you pronounce talaq in 1 month. There is no reconciliation in the second till the second month. You pronounce the second talaq in the second month and the third talaq in the third month without any reconciliation. Again, keeping in mind that the wife is not, it is not pronounced during the menstruation period. Now, after this three pronouncements, it becomes final. There was that talaq-e-biddat, which is a triple talaq, as you all know, that has been declared illegal by the court, and a new law which has been passed. Now, apart from that, you have khula and you have mubara. Now, khula is where a wife asks the husband to release her from the marriage, bonds of marriage. Now, when she is asking for a khula, the most important ingredient in the khula is that the woman has to give up something. She may give up meher, she may give up custody, she may give up anything, but some element of giving up something must be found in the khula agreement. Mubara is where it's a mutual consent, where both the parties agree to, there is no giving up or whatever it is. It's like any normal mutual consent. Now, amongst the Shias, they never recognize triple talaq, so that is not an issue. The other forms are recognized amongst the Shias. Now, if suppose part after mediation, the parties agree for a divorce, say it's a contested matter, parties agree for a mutual consent divorce. How will you draft the agreement? A contested case comes and valid case, proper case, they agree on a mutual consent, they agree on the terms for divorce. How will you draft a mediation agreement? If they have not executed a mubara, how will you draft a mediation agreement? My, I would say, first get the parties to execute a mubara during the mediation process, how much time is done, a proper mubara in accordance with the law. That agreement has to be, the same terms have to be again incorporated in the mediation agreement. You can tell the parties to file a mutual consent petition. Karnataka High Court in March 2024 Division Bench has held that a mutual consent petition by Muslims couple is maintainable on the basis of a mubara. So, because our family court had rejected such a petition as not maintainable, our High Court has held it is maintainable. So, on the basis of the mubara, to see that the other proceedings do not reflect, you can ask the parties to go and file a mutual consent, and then accepting that, saying that, declare that the mubara executed by the entered into by the parties is binding on us, and the marriage may be dissolved in accordance with the mubara. So that is one thing that you have to bear in mind, because otherwise you will be drafting an illegal agreement by just making a divorce mediation agreement with the divorce terms. So that is in case the both parties agree. Now, if suppose there is a case in view of the law passed in 2019 after triple talaq was banned, if suppose the case relates to a triple talaq that happened prior to 2019, you must be you should know that as per the new law, it's a very small enactment of 9 or 10 sections. It says that in the event of such a talaq, the custody of the children will be with the mother, and she's entitled for subsistence allowance. Now, it's a different matter if the parties agree on various terms, but this is what a mediator should bear in mind, because you should know the law. It's not that you expect the parties or to know the law. So you should be aware that there has been this enactment which says that in the event of a triple talaq after 2019 is anyway invalid. So if suppose some parties or a case comes to you that post 2019 there has been a triple talaq, you know that it is not valid in law. Now, as far as khula is concerned, same procedure, but ensure that the khula agreement incorporates a clause on giving up something. So that will take care of ensuring that any agreement that a mediator draws up amongst Muslims is valid in law. Now, why would a declaration from the court be necessary, which technically is not needed? What happens is if people want to migrate to some country or go out of India, either the passport office sometimes and sometimes the immigration authorities of other countries require a declaration from the court that the marriage is dissolved. It is under these, so you need to find out, because parties may say we may not go now, that is okay, but in future if they have to go anywhere or if they plan to migrate abroad, this will become a problem for them. So it is better that they get a declaration from the court that the Mubara or the Khula which they have executed is binding on them. So also, if suppose the Talaq al Ehsan and the Talaq al Hasan has been done and it's recorded, and the both the parties accept it, let that be incorporated. So you have these ways. So in an agreement, you don't have to then tell them to, if it's only the case of Mubara, that you have to ask them to file a mutual consent. But in cases of Talaq al Hasan and Talaq al Hasan, or even for that matter, Khula, you can incorporate that in the agreement in the case before you. This is as far as Muslims are concerned. Now, what about Hindus and Christians? Now, what happens is some years back, way back in 2012, one of the cases where the parties were Christians, wrong petition was filed under the Special Marriage Act. Divorce was granted, mediation agreement happened, divorce was granted. But a division bench of a high court came down on the mediation center, family court judge, and the mediator concerned for having executed a mediation agreement without verifying the provision of law. Because it was done under the Special Marriage Act when the parties were Christians and they had got married under the Christian rites and in the church and not under the Special Marriage Act, the mediation agreement itself was wrong. The court set aside the mediation agreement. I have noticed that many don't take the effort, if the marriage is registered, to look into what that certificate is, whether it's under the Special Marriage Act or whether it's under the Hindu Marriage Act or whatever, Christian Marriage Act. So, first duty as a mediator is to check whether the petition before you is in accordance with law. If you find that they have not married under the Special Marriage Act, you must make a note to say that this cannot be mediated, or else give them an opportunity to go and get it amended and then come back. But you cannot draw up a mediation agreement on the basis of a wrong enactment in which they have filed or wrongly filed a petition. That is one aspect of it. Second aspect is, if suppose, because there was a case just before vacation in the court, the parties are Muslims, they also get their marriage registered under the Special Marriage Act. They also execute a Mubarak. They file a mutual consent under the Muhammadan law, relying on our High Court decision to declare their marriage as dissolved in view of the Mubarak. That was referred for mediation. I don't know what happened in mediation, because I knew about that case because a particular advocate asked me. That could not have been referred for mediation, because under the Special Marriage Act, if your marriage has taken place in any form and you get it registered under the Special Marriage Act, then the provisions of the Special Marriage Act becomes applicable and not your personal laws. So that agreement, if it is drawn and a judgment, if it is being given on the basis of the Mubara, is actually illegal. So the court may have no time to look into it very carefully, but as a mediator, when such issues come before you, you should be aware of the law before you can tell the parties, go get it amended and come back. That would be the easiest way to get it amended. So this is one aspect of it. Second aspect is, in my personal experience, where some cases of our office were mediated, parties had arrived at a settlement. But unfortunately, the concerned mediator wanted involved one of few of the couple of the terms that involved apart from alimony was that the husband will release a property in favor of wife will release one property in favor. All terms have been agreed upon, but the concerned mediator refused to draw up the agreement, waiting for the parties to execute the deeds and come. That is a very wrong thing, because you have nothing in paper signed by the parties where they have agreed on those terms. Unfortunately, in that case, part because of the e-khata problem and all, they could not do it in 4 months. So mediation failed.
Quota number 5.
Court proceeded with ex parte judgment. So it was a case where parties had agreed. Now property remains that property dispute remains as it is. Alimony is not granted because an ex parte divorce. So ultimately it's not for the mediator to say you finish these things abcd and then come back. Whatever parties have agreed on within the framework of law, incorporate it into the get the parties to sign it. Because the recent supreme court judgment says, if the parties have signed a mediation agreement and if they go back on it without any valid reason or justification, they are bound by it. So you have to be very careful that you first not insist on getting all these deeds, release deeds done. The court will extend the time or court may not extend your time. But you, when the parties have reached an agreement, you need to draw up the agreement and then take their signatures and leave it at that. What the parties do in future is not, but you actually, which was a settled mediation, ended up as a failed mediation because no agreement was drawn and the parties suffered in the process. Now, this is one aspect of it. Second thing is, sometimes unknowingly during the drafting of mediation, one parent is asked to give up property rights of the minor. Please remember, no parent can give up the rights of a minor child in property. So such terms, you have to be very clear and firm that such terms cannot be incorporated into a mediation agreement. Now, in the event,
ಅಲ್ಲಿ ಮೂಲೆಯಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ
another aspect of the mediation agreements in respect of family law is custody matters. Now, one of the pillars of mediation is confidentiality. Now, in the course of a mediation of a child custody matter, if a mediator has interviewed and interacted with the child, please maintain your notes separately and not leave it in the file after it is over. It is usually in the case of unsettled matters, because the Supreme Court has said, though confidentiality is one of the pillars of mediation, in a child custody matter, they can call for the mediator's report as to what the child has conveyed. So please do not destroy your notes if you have interacted with the child. So, because you may be called upon because the court can call upon you to give what exactly what the child has disclosed to you. So, other cases, if it is settled, it doesn't matter, but it is in cases where it is not settled. So, as far as possible, if you feel it, you can avoid meeting the child, do it. If not, because anyway the Calcutta guidelines is being now enforced in our state, which says that a counselor's report is necessary. So you don't have to get into that role. Even assuming you get into that role and the mediation fails, you feel it is necessary to talk to the child, that may convince the parties, so be it. There is nothing to stop our role as a mediator, but you need to remember to maintain your notes, because you do not know when the court can call upon you, because once you have thrown away the file and the notes, you don't have anything in your records. So that is one major aspect. And I think this is all the I think I can think of that can cover what kind of what kind of pitfalls can happen while drafting a mediation agreement, and what care should be taken for that. what laws are to be applied and what laws you should be aware of. So if you all have now, it's open. Any questions, please feel free to ask. Yes, Mr. Umayyan.
No. Madam, due respect, in respect of the khula, what has been said, that the wife has to give some amount. Ahem.
Not amount, anything, something
Anything.
has to be given up.
It's not like that, according to my understanding.
Under the
According to my understanding,
no, if you also look at the various case laws on khula,
no,
you will find that it has something has to be
no,
given up.
I will just inform you. After that, the important point in khula is that suppose if the wife needs a khula, seeking release from the marriage, then she has to get the consent of the husband.
Husband
That
has
is-
to
that
agree.
is the
That's what
important point.
I'm not saying that it's a mutual.
No.
The husband
I-
has to agree.
No, regarding
Otherwise, there's no
payment,
khula.
no, regarding payment, whatever the dower amount paid, dower,
It's not clear.
whatever the dower, that is called meher. That is called meher. Whatever the meher paid, in that the wife is liable to pay 50%. And if the husband wants to waive off that amount also, he can do it. That is permissible.
There is no 50% rule. Sorry. In fact, she can. First is the husband has to agree. But there is one essential ingredient of khula is that she has to give up something. What it has to be given up? She may give up a meher, she may give up something maintenance, she may give up whatever it may be. But it is not at the 50% or there is no such rule under the khula.
And the main difference between Shia and Sunni marriages, there is a provision of mutta marriage under Shia, which is not applicable in.
See, muta marriage, I was only discussing dissolution of marriage. In mediation, we are not marrying people off. Muta marriage is a temporary marriage which is recognized by Shias, but we are not dealing with whether it's a dissolution. We are dealing with dissolution of marriage.
No,
We are not dealing with marriage.
no, my point is that is the only difference between
Yeah.
these two sects.
Muta marriage is recognized among Shias.
Yes, this is the only difference available between these two sects. That is my point.
Between Shias and Sunnis. Yeah. Yeah. After that temporary period, it gets dissolved.
Ma'am, my question is, you said just now about muta and divorce petition by a wife.
Your voice. Mr. Humayun, to come here only and ask.
Okay. Madam, you just now said divorce petition filed by a wife under Mohammedan law, which she is entitled to the only provision available to her. When she filed, when husband agrees to the terms of her divorce, just now you said that you have to go back to
It is preferable.
Mubarak. Why?
It is preferable because see, there will be allegations made in your divorce petition. If you don't want that
Right.
allegations to come on record, see, you can file a mutual. You can because see, the thing is, in your prayer in your divorce petition will not be to the effect that please dissolve a marriage on the basis of the Mubarak.
Sorry?
See, in a mutual consent on the basis of Mubarak, your prayer has to be in the suit.
No, I'm not talking about Mubarak. What prayers?
No,
Mubarak is
wait, 1
different.
minute. Listen. When they agree to a divorce, according to you, why should they file a mutual consent? Correct?
Yes, when you file a petition on section 2 of 39 Act, why all this? Why
No.
you driving the petition people
No,
to
wait,
against the
1
court?
minute. Then they have to amend the prayer.
Madam, prayers wise petition drafting is totally different. My question is, when section 2 petition is filed by a wife for a divorce, there will be various of grounds. There are 18 grounds, whichever the ground she opts. Once husband comes and says that I'm ready for a divorce, what happens?
On what ground?
Any ground, what happens?
If the husband has no problem of cruelty allegation, then it's
Exactly,
no problem.
madam. Cruelty will be dropped in a drop this thing, and he'll accept for them. You are saying something which both of parties should go and file a Mubarak, that a consent petition.
See,
That's what I understood from your.
the mutual consent petition provision is available in all other laws except of Mohammedan law. Correct? There's a provision of law, even in the Dissolution of Muslim Marriage Act, there is no provision for mutual consent. So when you are saying that the husband comes and says, I have no objection to divorce being granted on the ground of that can be done in the court. The mediation is not required for that. Even assuming it is done.
No, that is
No,
not my
even
question.
assuming it is
Why
done.
do you unnecessarily drive the parties for another petition?
You need not. Only thing you can ask them to draw up a Mubara agreement or a Khula agreement, amend the prayer and get it done in that.
Okay.
See, see, if you look at the Mohammedan law of divorce, there has to be reasonable grounds for divorce.
Okay.
Understood, no? So if you are saying that they cannot get along together, put it like that. If she has filed for divorce. But in how many cases have you come across where a woman has filed for divorce, the husband has come forward and said he has no objection for divorce?
Okay. No, again,
Ideally, it is possible, but practically, we have not seen any cases where they have
Yeah.
come forward like that. But if assuming, you can do it.
okay. Yeah. That's
But ideally, it would be better for both the parties that there is a Mubara, you're given the reasons, and then they have parted.
might be they not agree for that.
Hello, madam. Madam, I am from Gulbarga.
Yes, sir.
One marriage is performed according to the Christian law. And wife is,
What is he saying? Yeah, but what is he saying? I can't hear.
one marriage is performed according to the Christian law. And wife is Hindu and she converted to the Christian and she got a divorce under the Hindu law. What is the consequences of this case?
What is he asked?
Speaker on.
What is the question?
Sir, one
Sir,
second, please, sir.
Sir,
Gulbarga-
audio is not clear. Can you just repeat the questions little slowly?
One marriage is performed according to the Christian law and wife is Hindu and they got the divorce under the Hindu law.
See, if I understand right,
That
you
has been-
said if
that has been
marriage
referred
is
to the
performed,
mediation.
if I understand right, you're asking if the marriage is performed under Christian rites and one of the parties is a Hindu.
Yes.
If you look at the provisions of the Divorce Act, it says that if one of the party is a Christian and the marriage has happened, it can be dissolved under the Divorce Act. So that
No.
should not be an issue like how you have a problem with Hindus and Muslims, where both the parties have to be of the same religion. As far as Christians are concerned, if one party is a Christian and the other party is not a Christian, that marriage solemnized can be dissolved under the Divorce Act.
No, not there. That has been dissolved under the Hindu law, madam.
What is saying?
That has been dissolved under the Hindu law. Section 13A of the Hindu law. 13.
You cannot dissolve such a marriage under the Hindu Marriage Act. Because under the Hindu Marriage Act, the requirement is both the parties have to be Hindus. Under the Christian Marriage Act, it provides that where one of the parties is Christian, their marriage can be dissolved under the Divorce Act, which applies to Christians.
No, in this case, it is,
What is he saying?
madam, in this case, it is dissolved under the Hindu law, madam.
What you say? That is what I said. It cannot be dissolved under Hindu law because both the parties are not Hindus.
That has been referred to the mediation and sent back to the court also.
What? What is this question?
Answer ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ ಸರ್ ಅದಕ್ಕೆ ರಿಸಲ್ವ್ ಆಗಿಲ್ಲ ಮಾಡ್ಯಾರ ಸರ್ ಆಗಿ ಬಂದಿತ್ತು ಪೆಂಡಿಂಗ್ ಐತಿ ವಾಪಸ್ ಹೋಗ್ಯಾರ ಕ್ರಿಶ್ಚಿಯನ್ ಗಂಡ ಕ್ರಿಶ್ಚಿಯನ ಹೆಂಡತಿ
But I thought he asked if it can be done under Hindu law. It's very clear it can't be done under Hindu law.
that has been already divorced, and that Hindu law only that is on that.
And one more point I'll just make, because he asked the question on the Christian marriage. It is not necessary for a valid Christian marriage that it has to be performed in the church. You can get married like how you have a civil marriage under the Indian Christian Marriage Act before the registrar of Christian marriages. So if that certificate is there, it need not be by the church. So that is just, so you need to check when you get the petition whether the certificate enclosed is by the Christian marriage under the Indian Christian Marriage Act by the registrar of Christian marriage, or whether it's a church. It doesn't make which church what church. I think no doubts. Yes, it is 2019 Act after the triple talaq was declared illegal. But it says talaq is only defined as a single irrevocable talaq pronounced which happens instantaneous, which was the triple talaq, not any other form of talaq. Yeah, Shias need compulsory, but even then, you drop a agreement, keep two witnesses, it doesn't matter.
I have a confusion. Talak is done by men or women.
See,
Who?
there is
Man only.
one talaq is by a man, but that is called as a delegated divorce, by which where the husband delegates his right for divorce to the wife. Very rarely used, but if the talaq right to talaq has been delegated by the husband to the wife, she can divorce herself.
That
Yes.
is what that question. Talak? What is it called as?
Talaq e tofis. Tofis. Yeah. So usually what happens is it's it's called delegated divorce. Talak. No, but see, unless there are case laws where such divorces have been approved by the court, it is usually by the Privy Council. But unless there is something in writing where the husband has delegated the divorce, it becomes very difficult to prove.
She established it as being.
Yeah. So she can just divorce herself. No, that's a misconception that women do not have much rights in Islam, but it's a wrong misconception. No, that's what I said. If suppose it's in writing that he has delegated her right of divorce to the wife, it has to be in writing. Others, how will she prove it? Either in writing or verbal, some recording or something. So even assuming she is pronouncing talaq to herself, she has to follow that rule. Either one talaq and no reconciliation for 3 months. But she gives the divorce to herself. You can't say khula khula and it happens. Sorry. khula is where the wife asks the husband to release her from the bonds of marriage. No, she cannot. There is no concept. There is no concept of unilateral khula. And that is also something that is sometimes seen where some khula agreements, you don't see the husband consenting to the khula, the mullah draws it up. That is not valid because the concept is the wife asks the husband to release her from the marriage, he agrees to it, and she has to give us up. That's it. She can't say khula khula, that doesn't work. See, khula, divorce, and custody has nothing to do with each other. Parties may not be divorced and may fight a custody case for lifelong. That's a different issue. She doesn't have to mention anything about khula or any. That is only if there's a khula. If there is no khula, then there's nothing.
Allah,
Huh?
husband has given kula, but in the petition she has not mentioned that.
She has not.
Mentioned about the kula.
How does it matter? How does it matter? It doesn't matter.
Doesn't matter, no? Then no
See,
problem.
Supreme Court also says amongst Muslims, Azhar Hussein's case, that law of the parties is different, custody is guardianship are different. The personal law of the parties are separate. When you're dealing with a custody GNWC case, it's the child's interest which is paramount consideration, not their personal laws.
Okay.
So look at whether they are divorced or not divorced, a GNWC petition is still maintained.
Yeah, no.
So it doesn't matter whether there is kula, talaq, or anything. You may, if in a mubara you have agreed maybe on custody, or in khula you may have agreed on custody, you can still file a petition under GNWC for changed circumstances. That is open for all communities.
But once the kula is given, you said something she has to given up.
I said she can. It's up to her. She may decide to give up some jewelry. She may decide to give up a meher.
She may not.
She may not. But something small amount, something has to be given up.
Can you highlight about the flaws in the mediation agreement? Any which you have come across?
No, basically it is not knowing the provision of law.
Yeah.
Basically drafting agreements where parties are giving up certain rights of the minor. Then certain, and one more thing, yes. Whenever you all are, as far as possible, without trying to disturb the agreement that parties may arrive at, without disturbing the parties agreement that the parties may arrive at, because sometimes one wrong statement from you can really stop, the mediation can fail. When child custody matters are concerned, whether it's in a mutual consent or in a GNWC, as far as possible resolve the guardianship issue, because when that issue is not touched, later on it creates legal hurdles. If both the parties are okay, let them be joint guardians. If they agree to one person being a legal guardian, don't just drop an agreement on custody. If without disturbing the parties agreement, if they agree on guardianship, incorporate that clause, because otherwise you are pushing them into further litigation at a future point of time. It can be after 3 years, it can be after 4 years, but don't allow such a situation to arise, because the whole object of mediation is that the parties don't come to the court back fighting. It is. But most of the agreements, there is no reference to guardianship. Those issues are kept they don't touch on those issues. Parties would have not thought about it. So you need to be aware of it, and very discreetly, I would advise very discreetly ask the parties whether they are okay with the guardianship issue being referred to in a settlement. So I think there are no more doubts. We can wind up. Thank you for patiently listening to me. ಎಲ್ಲಿ ಹಾಕ್ಬೇಕು?
A big thank you to our resource person, Geeta Menon, for this wonderful session and clarifying all our doubts. Thank you to all the mediators present over here, the mediators from Kalburgi and Dharwad, and also the additional Registrar General Kalburgi bench and Dharwad bench. Thank you to our staff at KMC. Thank you once again.
This is put off.
Hello, Kalburgi bench.
Hello, sir.
ಸರ್
Hello. Sir,
ಇನ್ನೊಂದು
ಹೇಳಿ
ನಿಮಿಷ
sir.
ವೆಯ್ಟ್ ಮಾಡಿ ಸರ್.
ಮಾಡ್ತೀನಿ
ಜಸ್ಟ್ ಯಾವ್ದಾರ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೆಂಟೆನ್ಸ್ ಓದಿ ನಾವು ಇಲ್ಲಿಂದ ಸೆಟ್ಟಿಂಗ್ಸ್ ಚೆಕ್ ಮಾಡ್ತೀವಿ.
ಸರಿ ಸರಿ ಓಕೆ ಸರ್.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಆಯ್ತು ಆಯ್ತು. ಬುಕ್ ಕೊಡ್ರಿ. ಇಲ್ಲ ಓದ್ ಸೆಂಟೆನ್ಸ್ ಓದಿರೋದವ್ರಿ ಅಂದ್ರೆ ವಾಯ್ಸ್ ಹೋಗ್ತಿಲ್ಲ.
ಹಲೋ ಹಲೋ ಕಲಬುರ್ಗಿ ಬೆಂಚ್.
ಹಲೋ ಸರ್.
ಸರ್ ನೀವು ಮಾತಾಡಿ ಸರ್, ನೋಡೋಣ. ಏನಾದರೂ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಓದಿ.
ಸರಿ ಮಾತಾಡೋಣ.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಬ್ಲರ್ ಇದೆ.
ಹಲೋ ಹಲೋ
ಹಲೋ
ಹಲೋ ಹಲೋ ಹಲೋ.
ನಮ್ ಕಡೆಯಿಂದ ಕ್ಲಿಯರ್ ಇದೆ ಅಲ್ಲ?
ಸರ್ ನಿಮ್ ಕಡೆಯಿಂದ ಕ್ಲಿಯರ್ ಇದೆ ಸರ್, ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ನಿಮ್ ಮೈಕ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಸೆಟ್ಟಿಂಗ್ಸ್ ಇದೆಯಾ?
ಏನ್ ಸೆಟ್ಟಿಂಗ್ ಇಲ್ಲ ಸರ್, ಬಟ್ ನೀವು ಎಕೋ ಆಗ್ತದೆ. ನನಗೆ ಬರ್ತಾ ಇದೆ.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಎಸ್ ಸರ್ ಓಕೆ.
ಹಲೋ
ಹಲೋ ಹಲೋ ಹಲೋ ಹಲೋ.
ಏನಾದ್ರು ಲೈನ್ ಓದಿ ಸರ್.
ಹಾ ಸರ್. After due deliberation, consultation of preliminary draft regulation of use of artificial intelligence 2026 has been prepared under the Artificial Intelligence Committee, Supreme Court of India. These regulations govern the use of artificial intelligence in court, grounded in the principle of human primacy, transparency, accountability, data protection, and judicial independence, while establishing an institutional framework for responsible AI adoption across
ಸರ್
India.
ಒಂದ್ ನಿಮಿಷ ಸರ್ ಒಂದ್ ನಿಮಿಷ ಜಸ್ಟ್ ಒಂದ್ ನಿಮಿಷ.
ಅವ್ರು ನಾವು ಮಾತಾಡೋದು ನಮಗೆ
ಸರ್ ಇವಾಗ ಹೇಳಿ ನೋಡೋಣ.
As directed, the draft regulation of use of AI in courts 2026 are herewith published. Invite comments and suggestions. All stakeholders and the general public are invited to share their comments and suggestions on the said draft regulation through email address to Member Secretary, AI Committee, Supreme Court of India. But ನಾನು ಮಾತಾಡೋದು ನನಗೆ ಏಕೋ ಆಗ್ತಿದೆ ಸರ್.
ಓಕೆ ಸರ್ ಮತ್ತೊಮ್ಮೆ ಓದಿ ಸರ್.
Okay, sir. As directed, the draft regulation of use of AI in course 2026 are herewith published to invite comments and suggestions. All stakeholders and the general public are invited to share their comments and suggestions on the said draft regulation through email address to Member Secretary, AI Committee, Supreme Court of India.
ಸರ್ ಮತ್ತೊಮ್ಮೆ ರಿಪೀಟ್ ಮಾಡಿ.
As directed, the draft regulation for use of artificial intelligence in courts 2026 are herewith published. Comments and suggestions. All stakeholders and the public are invited to share their comments and suggestions on the said draft regulation through email address to Member Secretary, AI Committee, Supreme Court of India.
ಸರ್ ನಿಧಾನ ಸ್ಲೋ ಆಗಿ ಹೇಳಿ.
As directed, the draft regulation for use of AI in courts 2026 are herewith published to invite comments and suggestions. All stakeholders and the general public are invited to share their comments and suggestions on the said draft regulation through email address to Member Secretary, AI Committee, Supreme Court of India.
ಸರ್ ಮತ್ತೊಮ್ಮೆ ಓದಿ.
As directed, the draft regulation for use of AI in courts 2026 are herewith published to invite comments and suggestions. All stakeholders or the general public are invited to share their comments and suggestions on the said draft regulation through email address to Member Secretary, AI Committee, Supreme Court of India.
ಓಕೆ ಸರ್ ಇನ್ನೊಂದ್ಸಲ ರಿಪೀಟ್ ಮಾಡ್ತೀರಾ?
One ನಿಮಿಷ. As directed, the draft regulation for use of artificial intelligence in courts 2026 are herewith published to invite comments and suggestions. All stakeholders and the general public are invited to share their comments and suggestions on the said draft regulation through email address to Member Secretary, AI Committee, Supreme Court of India.
ಓಕೆ ಒಂದು ಲೆವೆಲ್ಗೆ ಅಡ್ಜಸ್ಟ್ ಆಗುತ್ತೆ ಸರ್. ಸರ್ ನಿಮ್ಮ ಮೈಕಲ್ಲಿ ಏನಾದರೂ ನಾಯ್ಸ್ ಸೆಟ್ಟಿಂಗ್ಸ್ ಇದೆಯಾ ನೋಡಿ.
ಇಲ್ಲ ಸರ್, ಇದರಲ್ಲಿ ಯಾವುದೇ ತರ ಸೆಟ್ಟಿಂಗ್ ಇಲ್ಲ ಸರ್.
ಯಾಕಂದ್ರೆ ನಾವು ಪ್ರೋಗ್ರಾಮ್ ಸ್ಟಾರ್ಟ್ ಆಗೋದಕ್ಕೂ ಮುಂಚೆ ಬೇರೆ ಝೂಮ್ ಚಾನಲ್ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡೆಲ್ಲ ಟ್ಯೂನ್ ಅಪ್ ಮಾಡಿ ಇಟ್ಟಿದ್ವಿ. ನಮ್ಗೆ ಬೇರೆ ಚಾನಲ್ ಗಳಿಂದ ಏನು ಎರರ್ ಬರಲ್ಲ, ನಿಮ್ ಚಾನಲ್ ಇಂದ ಮಾತ್ರ ಬರುತ್ತೆ.
ಹೌದಾ ಸರ್, ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ ಸರ್ ಒಂದ್ಸರಿ ನೋಡೋಣ.
ಸೊ ಅದಕ್ಕೆ ಸರ್
ಸೆಕೆಂಡ್ ಪ್ಲೇ ಇರೋದು ಇದರಲ್ಲಿ ಏನು ಸೆಟ್ಟಿಂಗ್ ಏನಿಲ್ಲ ಸರ್ ಇದು.
ಯಾಕಂದ್ರೆ ನಾವು ಬೇರೆದು ನಾವು ನಾರ್ಮಲ್ ಆಗಿ ಬೇರೆ ಮೊಬೈಲ್ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಸೆಂಟೆನ್ಸ್ ಎಲ್ಲ ಓದಿ ವಿತೌಟ್ ನಾಯ್ಸ್ಲೆಸ್ ಎಲ್ಲ ಟ್ಯೂನ್ ಅಪ್ ಮಾಡಿ ಇಟ್ಟಿದ್ರು ಕೂಡ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಇಂದ ಯಾವಾಗ ಕನೆಕ್ಟ್ ಆದ್ರೂ ಕೂಡ ನಮ್ಗೆ ಇಲ್ಲಿ ವೈಬ್ರೇಷನ್ಸ್ ತುಂಬಾ ಬರುತ್ತೆ.
ಹೌದಾ ಸರ್, ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ ಒಂದ್ಸರಿ.
ಸರ್ ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ಸರ್, ಅದ್ ನೀವು ಮಾತಾಡ್ತಿರಲ್ಲ ಸರ್, ಅದನ್ನ ಯಾವ್ದಾರ ಮೊಬೈಲ್ಗೆ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲಿ ಕ್ಲಾರಿಟಿ ಕ್ಲಿಯರ್ ಆಗಿ ಬರ್ತಾ ಇದೆಯಾ ಅಂತ ಒಂದ್ಸಲ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ನೋಡಿ ಸರ್.
ಬೇರೆ ವಿಸಿ ಕನೆಕ್ಟ್ ಮಾಡಿದಾಗ ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಬೆಂಗಳೂರು ವಿಸಿ ಇತ್ತು, ಅದು ಕನೆಕ್ಟ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ವರ್ಕ್ ಇದೆ, ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಸರ್.
ಸರಿ ಸರ್,
ಇದಕ್ಕೆ
ಆಯ್ತು, ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಪ್ರೋಗ್ರಾಮ್ಗೂ ಮುಂಚೆ ಕನೆಕ್ಟ್
sir.
ಮಾಡ್ಕೊಂಡು ಇನ್ನೊಂದು ರೌಂಡ್ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳೋಣ.
ಎಸ್ ಓಕೆ ಸರ್.
ಓಕೆ
Thank you,
ಓಕೆ ಸರ್.
Thank you.